Hello, Larry Good here again, NRA certified trainer, federally licensed firearms dealer, and owner of Southwest Washington Surplus in Vancouver, Washington. I'm a small business owner, a U.S. Air Force veteran, and I support my community through volunteer work and public safety advocacy, which is why I'm here to talk to you this evening. You may have seen my previous videos available on our YouTube channel and our Facebook page, talking about Washington law enforcement officers being overwhelmingly against Initiative 594 because of the infringement upon civil rights and intrusion into privacy that it represents. Let me expand further on another point made by the Washington Council of Police and Sheriffs: the burden on the system that would result from background checks on every single transfer, whether it's permanent or temporary. First, a quick rundown of the existing system in Washington State. All firearms dealers, that's anyone engaging in the business of selling firearms, either part-time or full-time, but not every person who sells a firearm from time to time. These folks are all required to be licensed federally and under Washington State's Department of Licensing. The Washington State license must be renewed yearly. Under the federal law, you're not allowed to get a license in order to shortcut or expedite paperwork for yourself. You must intend to engage in the business. This standard is subject to a lot of interpretation, as is a lot of other things that the ATF applies to firearms dealers. Many people who may see this will never have had the experience of buying a firearm at all, and many probably have never bought a new firearm from a dealer. So I'm going to let you in on some secrets about buying a firearm and about firearms crimes. In order to purchase any firearm from a dealer, you and the dealer must jointly fill out an ATF Form 4473. Which is 6 pages long. To purchase a handgun, you must also fill out the application to transfer pistol for Washington State. Both 4473s and the pistol transfer forms record the serial number of the firearm, creating a traceable record. The pistol form is filed with the state. The 4473 is required to be maintained at the dealer's premise. So Washington State already has a handgun registry. It's simply not very well organized, as most of these pistol forms are filed in paper, and the processing of these forms is anecdotally said to be consistently 10 months behind. There's a mandatory 5 business day waiting period to take possession of a handgun. With weekends and a holiday, this wait can stretch to as much as 10 days, and sometimes does. If you start on a weekend and have a holiday in the period, this waiting period is waived if you already possess a valid concealed pistol license, which generally takes about 30 days to get the first time around. The background check for concealed permits is actually more stringent than the basic firearms eligibility, and the misdemeanors in recent history will prevent you from getting a CHL, but not necessarily from owning a firearm. The exception to that would be a domestic violence conviction, even a misdemeanor, which removes your firearms rights for life. The background checks for pistols are performed by your local police or sheriff. They perform the exact same FBI NICS check that a federal firearms dealer would perform. In some states, there is no local law enforcement check, and all checks are performed by FFLs. The criteria for issuance, whether going through the FFL or the state, is exactly the same as the NICS check that an FFL would perform. They don't deny you based on any more stringent criteria, although they do have better information about involuntary psychiatric commitment if and only if it happened in this state. The only real difference is that your serial number is now recorded by the local law enforcement agency so that they know exactly what you have should they ever want to confiscate it. The NICS check can have 3 possible outcomes. You can get a proceed, a delay, or a deny. Proceed is easy and is the vast majority of people. Over 90% immediately proceed, and 99% eventually get a proceed. So right there you can see that I-594 would be 99% wasted effort, time, and money, as most of the people get a proceed. The second status you get is delay. This is generally just an annoyance, but it could be life-threatening for someone who is currently being stalked or threatened. Unfortunately, people are delayed on a regular basis. Out of the 99% who eventually get a proceed, a good number of them got a delayed notification first. The number of people delayed varies very widely sometimes. We have had entire days or weekends when the system was unavailable due to maintenance. Sometimes that maintenance was announced in advance, sometimes not. We've had lots of times when the system simply returned lots of delays with no explanation. Sometimes a person gets delayed for a few hours, but sometimes it's days. We've had days where every single NICS check was delayed, and other days where some people are delayed and others not. It doesn't seem to correlate with their actual backgrounds either. It could be somebody who's a first-time gun buyer or someone who collects guns on a regular basis. It could be a young person with very little history, or it could be an elderly person who's never had even a spot of trouble with the law. We perform the same check every time someone buys a gun, so adding a further check and a delay would not stop somebody from using a gun they already have in their possession if they were intent on harming someone. Why should there be a waiting period for someone who already owns a gun? In 2012, 9.5% of all NICS checks were delayed. In 2013, it was 9.2%. So you have about a 1 in 10 chance of being delayed by the federal check alone, no matter what your record looks like. Compound that with the delays from the state level checks. Over 25,000 people have had so many delays that they have had to establish an appeals file with additional information in order to prevent being delayed when they purchase. This kind of brings to mind the false positive rate of the secretive no-fly list that even caught Senator Kennedy 5 times. Normal people without access to the halls of power end up just suffering through the inconvenience and the embarrassment with no special route to get these kinds of things fixed. The New York Times on August 18th of 2013 reported in an article titled "A Flawed Background Check System" that the FBI performed nearly 17 million checks in the last year, which is about 6 times the number of a decade ago. This is just another sign of the ever-increasing encroachment on privacy and how government programs always expand beyond their original stated intent. But the thrust of the article is on how many false positives the system generated and how that negatively affects the career prospects of ordinary people on a daily basis. How much more would this affect somebody who's suffering from an abusive ex-relationship or a stalker? What will these expanded background checks eventually be used for? Will they someday release your firearm purchasing records to potential employers? Oregon Firearms Federation recently reported on the rate of delays and failures in Oregon's system, which is instructive for us because in Oregon, all FFL transactions and private transactions performed at gun shows have to be checked. It's been a dismal failure there, particularly in regards to follow-up on denials. According to an executive summary about, quote, "the investigations that Oregon State Police is conducting regarding denied firearm transactions through the Firearm Instant Check System unit. Of the 331 denial investigations, only 8 people have been arrested. That's a total of only 2.4% of the people denied." And of course, there's no way of knowing how many of these people taken into custody were arrested for actual offenses and how many were simply victims of the same sloppy record keeping that kept the other 323 people from completing an immediate transfer. Our system isn't prosecuting the people who are denied already. How will it help to add thousands more checks when, again, 97+% of these checks will be manpower, time, and money wasted on a perfectly ordinary citizen who will get an immediate proceed? Finally, let's talk about denials. The NICS overall denies not quite 1% of all background checks. This is thousands of sales each year out of millions of sales. Sometimes this turns out to be an erroneous identification of an innocent person as being prohibited. In hundreds or thousands of cases, this is due to erroneous identification. In hundreds or thousands more, it's due to out-of-date information for people who were arrested but never convicted. They may have been wrongly accused, expunged, or even pardoned. These people eventually get a proceed. Of the few who are charged with attempting to illegally purchase, most are found not guilty when tried for the attempted purchase. Each year, only a handful, literally a few dozen out of these 80,000 annual denial numbers in the entire United States, are ever convicted for an illegal purchase. Last year, in 2013, U.S. Senator Kelly Ayotte and U.S. Attorney Timothy Heaphy exposed the fact that of nearly 80,000 denials in 2010, only 44 cases were prosecuted by the feds responsible for enforcing the law. 44 cases. Over 4,500 of those denials overall, about 5%, in 2013 were overturned when the denied person pursued the effort long enough to get it corrected. Thousands more probably gave up on the very involved process of appealing. So the number of people who are actually being prevented from buying a firearm by the background check process is somewhere around 0.9%. For this, we spend billions of dollars annually. Even of the people legitimately being denied, in this age of increasing criminalization of formerly allowed behavior, how many are even violent offenders? Again, we have no data, but we can speculate. What about violent crime? The National Crime Victimization Survey in 2003 says that crimes involving a firearm represented only 8% of the 6.3 million violent crimes of rape, sexual assault, robbery, or aggravated and simple assault. While it's true that about 66% or 2/3 of the 15,000 murders in 2000 were committed with firearms, more people die in car accidents than are murdered each year, and the rate of murder has been steadily dropping everywhere but those few densely urban areas with strict gun control laws and no option for concealed carry. Since Illinois was forced by Supreme Court decision to authorize a concealed carry permit process this year, murder rates in Chicago have dropped by 25% even prior to the issuance of actual concealed carry permits. More people are literally murdered with hammers than are counted in the FBI's uniform crime statistics as being murdered with a so-called assault weapon. Only 1 to 2% of criminals interviewed in prison indicate they purchased a firearm at a gun show, and there are no statistics on whether these people committed their crimes before or after purchasing their firearm. A well-reviewed study by Gary Clegg in 1995 found that there may be up to 2.5 million defensive gun uses every year. Most of them are hiding below a threshold of official attention and thus unreported for various reasons. I lied to you a couple minutes ago about letting you in on my secrets. The truth is, none of this is a secret. In the age of the internet, this information is easily and widely available and is certainly known to the folks who are pushing I-594. So why are they blowing smoke up your skirt about the benefits when they know it doesn't stop crime and imposes a burden only on the law-abiding? If we give them the most charitable interpretation of ignorance or stupidity and assume they don't know the facts, then why would we listen to them on any substantive policy item? Is I-594 constitutional? Well, it's certainly a financial burden on ownership of arms. It makes it more difficult from a time and process perspective as well. The Second Amendment to the Constitution of the United States is pretty clear in that the right of the people to keep and bear arms shall not be infringed. Regardless of dangling clauses as to why this is so, it's still very clear. There are good and solid reasons why this is so, but that's too much to go into for this already too long video. The Washington State Constitution also has protections. The right of the individual citizen to bear arms in defense of himself or the state shall not be impaired. This would seem to be pretty clear as well, and requiring a costly, time-consuming process would definitely meet the definition of an impairment. If you prevent me from buying or borrowing a firearm for up to 10 days, longer with weekends and holidays, that's definitely impairing my right. Constructive limitations on civil rights have always been held to be unconstitutional in the past. Things like poll taxes, for example, which is a very similar situation. Imposing fees and costs on private citizens exercising their civil liberties was wrong when it was being used by Southern Democrats to prevent African Americans from voting, and it's wrong now. Another test of constitutionality is uniform enforcement. A law which is impossible to enforce uniformly is rightly considered to be unconstitutional, because it will be impossible to apply fairly and equitably, inevitably leading to selective enforcement on the basis of personal bias. This I-594 is such a law. There are no resources to enforce it equally. Ipso facto, it will be enforced unequally. It will be a hammer brought down to over-punish people who are caught doing something minor just to make an example. After all, if people become felons, they lose their right to vote along with their firearms, and it makes it that much easier for the side that doesn't want people to have guns anyway. Win-win for the elites, not so much for the rest of us. How would I-594 affect faith in our participatory form of government? After all, we are the people, and in our country, government is of the people, by the people, and for the people. So that's us. We're all responsible. There is no appeal to external authority. We're going to end up with the government we deserve, for good or ill. A republic if we can keep it. There's a process for amending our Constitution. It's deliberately got a high bar of difficulty. If you can't convince enough people to get it changed, it's probably because it wouldn't be a good idea to change it. It's a basic tenet of leadership and well known in my military background that you never give an order which is absolutely certain to be disobeyed, because it undermines confidence and belief in authority. A great many people will either not know about this I-594 law or choose to ignore it because they know it will be impossible to detect a violation given the literally millions of unregistered guns in circulation. There's zero benefit in punishing someone for ignorance, making a criminal of a previously productive member of society and possibly depriving them of their livelihood. And when you've lost Main Street America's belief in a particular law, there's no point in keeping it on the books, as the recent decriminalization of marijuana in our state demonstrates. I hope that this has been informative, and while I do hold strong opinions, I'm not trying to foist them onto anyone, which is why I've tried to keep emotion and opinion to a minimum, while maximizing the factual information and using informed speculation. If you find this information factually useful to yourself or someone who could use an education, you may want to subscribe to this YouTube channel and follow Southwest Washington Surplus on Facebook and Twitter. Please share this video widely and vote no on I-594. Your ballots should be in the mail any day, and you have the opportunity to make a change for the right. Thank you.